judgment. Court of Common Pleas is now in session. The Honorable Eugene presides.
May be seated. We're on the record. This is case number 22 CR 000563, State of Ohio versus Kenneth L. Dunham. The case is set for a pretrial this morning. Mr. Dunham is in court, self-represented. On behalf of the State of Ohio is Assistant Prosecuting Attorney Eric Feusel. The charges in this case were filed by indictment by the Lake County Grand Jury on August 26, 2022. Total of 5 counts. Count 1, improperly handling firearms in a motor vehicle, felony 4, with a forfeiture specification for a firearm and related accessories. Count 2, engaging in prostitution, misdemeanor 1. Count 3, using weapons while intoxicated, misdemeanor 1, and the same forfeiture specification. Count 4, possession of marijuana, minor misdemeanor. Count 5, open container, minor misdemeanor. The defendant was arraigned in front of Judge Condon on September 12th, 2022. Bond was reset at $5,000, cash surety worth 10%. A not guilty plea was entered at that time.
Sorry, that not guilty plea was not entered by me. It was entered by Judge Condon.
Okay, that's good. And the defendant has been out on bond. The matter is set as a pretrial today and has not been set for a jury trial yet. Mr. Feusel, tell me what's the case about?
Thank you, Your Honor. This case is involving Mr. Dunham is a case that involved a call to a hotel where Mr. Dunham was approaching the door. The state's position is that he was approaching the door to engage in prostitution. At that time, he was stopped by officers. Following the conversation, an officer had located, and this is what leads to going to the car, a pocket knife on the defendant's person. At that point in time, they offered to take the knife back to the car. Mr. Dunham refused. In addition, marijuana was found on Mr. Dunham. They did a drug search of the sniff of the car. An alert took place. They searched the vehicle. Part of that search, they located the firearm. That was specified in count 1. The Glock 10 millimeter with 2 load magazines and 1 in the chamber found in the vehicle under the driver's seat.
So, when you say engaging in prostitution,
He was going to, he had been in contact with a known prostitute at that time and was about to exchange had set up for him to be involved in prostitution, where he was going to be going to receive services.
I object. Hearsay.
Well, all this is hearsay right now. This is just a pre-trial, it's not the trial. So,
All due respect.
pardon? So, was this set up by the police?
They received a phone call or a tip in the midst of of all this taking place. They received a phone call that this was going to happen, so then they showed up. It's not necessarily set up by the police.
Okay, had the police been focused on Mr. Dunham before
Not
this?
focused on Mr. Dunham, no.
And the firearm was in the motor vehicle?
Correct. The police department witnessed and viewed Mr. Dunham pull into the parking lot, park his vehicle, exit his vehicle, and approach. This was an outdoor motel, and approaching the door of the motel where he was approached, and they actually entered into the hotel's premises. So he was able to see that he was the only occupant of that vehicle, he exited the vehicle, that he approached the hotel, that nobody else was in the vehicle at that time.
I object. I was not driving. I was traveling. And,
So there was somebody else driving?
No.
Your Honor, no, he would refer to driving as traveling. I would argue as the statement point that traveling, in this case, was him traveling in the vehicle, operating the motor vehicle.
the motor vehicle was classified as a motor vehicle with 10,000 pounds or more, or traveling with passengers. That is the definition of a motor vehicle. I had no passengers, neither me or my estate, and I was not traveling for hire. I was not driving for hire.
Okay. And you are self-represented?
The Kenneth Dunham estate is present in court today.
Who's present?
The Kenneth Dunham estate, Kenneth LaVelle Dunham estate is present in court. This is prima facie evidence that the individual is in court today
Okay, well, who's charged in this case?
of the estate.
The estate is charged?
Yes, sir.
Okay. And so then who would be going to trial? The estate.
I'm here to settle the matter, sir.
Okay, and when you mean settle the matter, what do you mean?
To my understanding, there's been a true bill and an account on a ledger, and I'm here to settle that account.
In what way would you settle the account?
Through a credit transaction, sir.
Through a what?
Through a credit transaction, sir.
What do you mean through a credit transaction?
Through regular means of tendering payment, sir.
Okay. Money is only tangentially involved
I understand.
in this. Your freedom is what's at stake here. Whether it's you or the estate of you, this is a felony charge.
I state on the record, I am not that person or that individual. I am a living body, spirit, and I'm here as beneficiary and appropriate persona, a special appearance,
Okay.
with reservation of all common law rights.
All right. Have you ever been in front of a state court previously?
I don't understand the nature of this question, to be honest.
Well, what do you call your physical body?
Temple, as it is written in the Holy Bible.
Okay. So has your temple ever been in front of a state trial judge before, common pleas or municipal?
No, sir.
Okay. So you may be unfamiliar with procedures and the law that I have to apply.
What law is that under?
Well, I have to apply the Ohio Revised Code. Title 29 is what I'm required to apply here.
Did you swear an oath to uphold the United States of America Constitution?
Yeah, I
The
did.
American Constitution?
And the Ohio Constitution, right?
And this is judged under statutory law, to my understanding?
All crimes in the state of Ohio are statutory. My office preceded the state.
Where can I find the published rules for statutory law?
The rules
The published rules for statutory law?
in Title 29 of the Ohio Revised Code. They've been in that chapter since 1953. But this court predates the state. This court was established by Congress in the Northwest Territories under the ordinance of the Northwest Territories.
So if this court is granted by Congress, you have the delegation of authority from Congress in all due respect?
Yeah, it's in the congressional record. So when you say you want to settle this matter, what that means to me as a state judge is that you either want to plead guilty as charged or to some other offense acceptable to the state such that the case wouldn't go to trial.
It's to my understanding that this is an equitable charge, a charge of equity.
No, it's a criminal charge, felony charge.
Okay, and is there any commercial contract involved? Is there any
There
charge?
might have been a commercial contract involved on the prostitution, but not under the improperly handling firearms in a motor vehicle or the drug charge or the open container charge.
That's
Well, we'll preserve your objection, and you can certainly appeal to a higher court.
I have questioned the venue in the first arraignment through Willoughby Municipal Court, and none of my affidavits or none of my requests for subject matter jurisdiction was granted.
Okay. Well, you made an initial appearance in Willoughby. You weren't arraigned in Willoughby. You were arraigned in the Common Pleas Court.
That was a video conference that I was coerced into going to on behalf of my estate.
Who coerced you into doing what?
That was a video arraignment that my estate was coerced to go
Where were
to.
you located in the video arraignment?
I'm sorry?
You weren't in the courtroom on the video?
No, that's the whole thing. I'm not understanding how the video arraignment is court at all.
Okay. Well, that's irrelevant because once the grand jury indicted you, those are the charges, and everything that happened in Willoughby is, so to speak, water under the bridge.
But I'm just putting it on the record.
Okay,
This was
so
from the courts.
I mean, I have a document that you filed. It says notice of conditional acceptance. You filed it September 12th, 2022, and it says, I, Kenneth Dunham, and am in conditional acceptance of the true bill. I do not agree with the forfeiture specification. I conditionally accept upon the condition that all withheld property be returned to its true owner, Kenneth Dunham. One set of keys, a black Fifth Amendment pocket knife, Glock 20, 10 millimeter. I choose not to argue the facts of this matter, nor do I wish to seek any other benefit. I wish to stay in honor and agree with my adversaries quickly, seek to make amends with my brother as it is written in the Holy Bible. I consent to the performance of any bill with consideration in which I may be liable as surety by default or failure to perform on. The language that you're using is not what I'm accustomed to here. When somebody says they wish to agree with the state and resolve the matter, that means that they are confessing in open court that they have committed the crime that the state calls a crime, and but they have to do that knowingly, voluntarily, and intelligently. And when you say with conditional acceptance, and based upon some of the language that you're using here, it doesn't sound like you want to plead guilty to anything. Is that correct?
I don't agree with the state, and no, I don't wish to plead.
Okay. All right. So, you've never been to a trial before, right? Because you've never been in a court.
Your Honor, he has had a prior record. In 2009 was a conviction for carrying a concealed weapon in Cuyahoga County. That was a reduction to misdemeanor and pleading to. He's also had a number of traffic cases with in-state convictions, so he has been before a court, before a judge, whether or not he can identify if that was Kenneth Dunham in person or not. I will state from the state that it was Kenneth Dunham bearing the same social security number that behalf of this Kenneth Dunham was on those cases.
Same fingerprint?
On behalf of the Kenneth Dunham estate, I never went to trial for any case, to answer your question
Okay.
directly. So,
And thanks for answering it directly, because that was my point. How do you think that you would do in representing yourself at a jury trial?
Seek to settle the matter on behalf of.
But that means you wish to plead guilty.
No, I don't wish to plead guilty.
Okay, so what other plea is there? No contest? If you want to plead no contest,
No,
I'll let you plead no contest.
I don't wish to plead guilty.
Okay. So then, we will set this for a trial. The default is it's in front of a jury. The default is a jury trial. If you don't want a jury trial and you want the judge to do everything, then you have to tell me in open court after I advise you of your rights, and you would have to sign it.
I've actually made it that notice. I wasn't able to file it because it had been notarized.
And what is that? Something you filed today or tried to file today?
Affidavit, yeah.
And and what's it about? What's it say?
This is basically saying that I was in conditional acceptance for September 12th on behalf of my estate, but Judge Condon chose not to answer a certain set of questions that I had, and I chose to revoke that conditional acceptance
Okay.
on behalf of my estate. And it was just something like
Okay. So you're saying that the notice of conditional acceptance that you filed on September 12th has been revoked by you. Is that correct?
yes, it has been revoked. I mean, it's beneficial on behalf of my estate.
Okay. All right. So I will set the matter for a trial by a jury.
And I'll reserve all common law rights.
I'll let you reserve whatever rights you think you have that you want to reserve. When well, first off, how long does the state think to present its case?
1-2 days tops.
All right. And Mr. Dunham, how long do you think for your defense, to present your defense?
I object to being called Mr. Dunham.
What do you want me to call you?
Call me beneficiary.
Okay, when's the beneficiary? How long does the beneficiary think it'll take to try beneficiary's case? Okay. Tried about 400 cases, jury trial, so I'll give it a, what I expect to be a normal amount of time. If we go over, we go over. If we go less, we go less. When would the state be ready to present its case?
Your Honor, the state at this time, we would be ready to present this as soon as the court is ready. However, at this time, because the defendant has not yet been determined being to represent himself, we have not shared discovery with him. I know he's going to be a period of time to be through that discovery. As soon as that determination is made by the bench, we will go ahead and provide discovery to Mr. Dunn.
I might actually request judge order for discovery today if possible.
Pardon?
Actually request judge order for discovery today if possible.
I missed the what'd you say before, the two words before for discovery?
I request the judge order for.
Oh, okay, you want me to order discovery to, okay. So what I need to do, I noticed in the record you did have an attorney at one point. Was that an attorney you engaged, or was that an attorney provided to you by the Willoughby Municipal Court?
That was actually for the contempt of court in regards to the case number, I'm sorry, 22 CRA 01255 arising out of Willoughby. And he changed it over.
What was the contempt for?
The contempt, he made a judicial discretion that excuse me, apologize.
Was that a non-appearance in the case?
It was for non-compliance during the preliminary hearing. He continued to object. When they were not able to hold the preliminary hearing because of the objection.
That question subject matter jurisdiction as I do at every court on behalf of my state, and he continued to call the police officer to testify, and I had to object.
Okay.
And reservation
Well, I
of rights.
can appreciate that, and you only have to object once. An objection once preserves that objection throughout the case, and you can appeal on the overruling of that objection. So if you object to the jurisdiction of the court, if you object to my jurisdiction, if you object to anything with regard to procedures, we can put that all on the record at any time. And then you don't have to renew that objection. I will recognize the objection throughout, and whatever ruling I make on the objection would be considered to be the same response throughout. But you don't have to make the same objection 50 or 100 times such that the proceeding is interfered with. Because then that wouldn't be an objection, you're just being obstructive.
I was actually exercising my rights on behalf of my state because Magistrate Barr made a judicial determination to appoint counsel, in which that is against my religious beliefs, in which I choose to remain.
Who was that counsel?
I'm sorry?
What the name of the counsel that he appointed?
Attorney Jeff Black. He was a
Jeffrey
standby
Black.
counsel.
Oh, okay, so he was standby counsel. Okay.
And
that's normally what's done if somebody is self-represented. We normally have an attorney appointed so that if the self-represented person has a question about law or procedure, or if the pro se individual violates the rules and I have to remove the person from self-representation, then the attorney would take over.
I choose not to have anyone in my stead.
Okay, then that means that I have to make sure that under the law you are competent to represent yourself. Because one of the rules is that if you are not competent, well, if I allow you to represent yourself and you are ineffective in representing yourself, you can never claim that you had ineffective assistance of counsel. Do you understand what I just said? I mean, if you represent yourself, you can't say, well, the judge let somebody really bad, didn't know what he was doing, represent me. Especially when you're telling me that you're two people. The beneficiary is on trial, and is it the estate that's representing, or who would be representing the beneficiary?
That would be the appropriate persona.
Okay.
As a witness as well.
All right. So the estate can never claim that I appointed somebody who was incompetent to represent him. And let me just speak off the cuff here for a second. And I've seen this when I was an acting judge in the municipal court, where an individual who claimed that that the state could not require him to have a driver's license was defending himself for no driver's license. And it took the jury 28.3 seconds to convict him, because they went back to the jury room, they looked at each other and say, you required to have a driver's license? Yep. Are you required? Yep. Guilty. And then they just came out and found him guilty.
Was that a jury of his peers?
Sure was. But they weren't, they didn't subscribe to, what UCC 1-308? What's that say?
What is UCC, Uniform Commercial Code?
Yeah, what's 1-308 say?
1-308 is reservation of all rights.
Okay.
Contracts.
You understand, this is not a commercial transaction, and the UCC doesn't apply to the proceedings here. The Uniform Commercial Code is an operating code in dealing with
It's
commercial
my
transactions.
understanding that all crimes are equity.
No, all crimes are statutory in the state of Ohio, and if it's not written down, then it's not a crime.
The crime would have to serve a victim, property damage, or a damaged person.
Well, the state's the
That's a
victim.
crime.
The state, the government is the victim in all crimes.
The state cannot be the judge, the prosecutor, and the victim.
Well, that's the way it is.
That's
And the
law.
problem is with you representing yourself and making the statements that you are making. I don't think that the jury, maybe they will. Maybe the jury believes in everything you're saying. And that's their right. They're the jury. They take an oath to uphold the law, but if they believe that that's the law.
This is the bankruptcy court, so it's all equity.
What's a bankruptcy court?
The United States is bankrupt according to House Joint Resolution 192.
Okay, well, I might agree with that. I think the United States is insolvent. But that's not what the issue is here. The issue is here, grand jury charged you with a set of crimes. The state is required to prove that beyond a reasonable doubt. You're entitled to a defense. The state would have to prove it beyond a reasonable doubt. The jury would be told the law as I understand the law as it is written, and they apply the law to the facts that they find to come up with their verdict. And then if they find you guilty, then it's my duty to determine what's the appropriate sentence. So you have no felony record in the state of Ohio?
No, sir, my state has never been charged, convicted of a felony.
Okay. Well, that's good for you.
My state has not came before the court other than speeding tickets in Willoughby about 6 years ago. I believe.
All right. Okay. How old are you? How old's your estate?
32.
Okay. So you've been generally law-abiding all your life?
Yes.
Okay. So you followed the rules that the state said?
Yes, yes. I followed the rules of the state within America and the constitutional laws and the laws of God. No one's perfect, but try to stay within the realm of all laws.
Okay, I understand what you're saying.
Better society.
So the issue that is immediately present is whether I let you represent your estate in front of the jury, or whether I am required to appoint counsel because you have such an unfamiliarity with the law or procedure, or an unwillingness to comply with the rules of procedure, such that it would be disruptive and wholly frustrating the conduct of the case.
I come in peace.
Oh, I understand that.
I just choose to have my rights protected that the Constitution ensures. I feel like all the constitutional rights should be available for the people of the nation, and not just representation for counsel on behalf of the courts obtaining jurisdiction. I'm just aware of my person and where I stand as a man of God.
All right. So, what I want to make sure you understand is that it's possible that a jury would find you not guilty without going through all of the unfamiliar territory of claiming bankruptcy court, UCC, the estate of, the state has an uphill battle on any case because it's always on the state. They have to prove the case beyond a reasonable doubt. You don't have to do anything. And what I'm saying is you don't have to confuse the jury with all of this other stuff.
It's not confusion. I have to be more precise in my language due to the use of words. They're very powerful, so I'm very adamant about the use of my words, especially in this setting on behalf of my state.
But all of that won't get you anywhere except you make the objection at the beginning, like now. I rule on that, and that objection is preserved throughout the case. And I will say that it's preserved throughout the case. So you object, for instance, to the court's jurisdiction. Okay? Then I will overrule the objection and state for the record on the grounds that I do have this court does have jurisdiction.
What is
Well, I don't have to explain the jurisdiction to you. I would have to, the state would have to explain the jurisdiction to the Court of Appeals. Because once I make a ruling on the case, then once all the rulings are made, then whoever doesn't like any of those rulings can appeal it to a higher court, and then whoever has the burden of proving that in the Court of Appeals would have to show the Court of Appeals that there is some error in my ruling. But I'm telling you that this court has jurisdiction over these crimes, and that I, as an officer of this court, have the authority and the jurisdiction to try this case and to try you or your estate, whoever is the human being on trial. So that's my ruling, and that would be my ruling no matter how many times you raise it. And the point is, if you raise it, for instance, in front of the jury, after I've already ruled as a matter of law that the court has jurisdiction and that I, as a judge, have the authority to preside over this case, then I would hold you in contempt and have an attorney, if I were to let you represent yourself, have an attorney represent you from that point forward. So there'll be nothing to be gained by being obstreperous or making repeated similar objections. So all of the basic objections would be made outside the presence of the jury right at the very beginning, because it's not for the jury to decide whether this court has jurisdiction. If the court didn't have jurisdiction, they wouldn't be here. You understand what I said?
No.
No? If you don't understand that, then probably you are not of sufficient understanding to represent yourself.
I hear you, sir, but that is a conflict of interest in regards to the case, because it's things like that or statements like that that conflict with my estate's ability to defend itself.
Okay. Well, give me an example of how what I just said interferes with your ability.
Back on what you just said, you basically just said that I had to use choice words on behalf of my estate in front of a jury, but those same choice words that I wouldn't use would be a detriment to my defense. In respects to the court, like I said, I don't choose to be a problem or argue back and forth with the courts on behalf of my estate. I just choose to use the correct terminology to have a proper defense. That's all.
Well, I can appreciate that. We all should choose our words carefully to express exactly what we mean. But do you understand that when I say that you need only object once to a certain type of thing, whether it's jurisdiction, whether it's venue, whether it's the authority, you only object at the very beginning, and that ruling stands throughout?
I won't make more than one objection in regards to the proceedings of this case or charge.
Okay, so go ahead and make your objection so that I can rule on it, and it'll be a matter of the record. You know we're recording. This is a court of record, so we record everything.
I challenge the subject matter jurisdiction of this court.
Okay, and the basis for that challenge?
I'm sorry?
And the basis for the challenge?
The basis of the challenge is me and my state have the constitutional right to understand that the court has subject matter jurisdiction.
Okay. And when you say constitutional right, are you talking the U.S. Constitution and the Ohio Constitution?
I'm talking American Constitution.
All right. So you don't recognize the United States of America?
My state recognizes it well, but I have the right to travel in private capacity as well in the Americas. As one of the people of the nation, I reserve that right and that title to be private citizen of the American Republic.
Okay.
Civilian.
But you understand that the U.S. Constitution provides for freedom of travel? anywhere in the country.
I'm aware that I'm free to travel, yes.
Okay. All right, so that objection is overruled, and you don't have to raise it again. You've made your objection, you've given your rationale for it, and I've made my ruling. So we never have to hear that objection again. Okay?
I'm aware of what just took place.
Okay. Any other objections?
Not at the moment.
All right. And if you do, we'll bring it up at the earliest opportunity. I'll give you the ability to state your basis on the record for it, and I'll make a ruling, and then that'll be the last time we'll hear that objection. And that's how we'll do this. But in front of the jury, I don't want to prejudice the jury against you because they think that you are a nonconformist. Because if they think that you have an inability to conform to the law, they might find you guilty just on that basis. Pardon?
To the law, to the code, to be exact.
No, the Uniform Commercial Code will never come up in this trial.
No, not the Uniform Commercial Code. I mean, the statutory code, to be exact.
The revised code, yes, that'll come up frequently. The whole case will be about
I just want
the
clarification on
Ohio Revised Code.
what you consider law in this state.
The law is the Ohio Revised Code. That's the law that I'm required to apply here. For instance, count 1, 2923.16b. That's the law that I have to apply.
Are you required to abide by the laws of the land?
The laws of the land,
Yes.
I'm required to comply with the U.S. and the Ohio Constitution, if that's what you're talking about.
I'm just piggybacking on what I asked earlier on behalf of my state. I asked that you swear an oath to uphold the Constitution of the Americas.
Of the United States. I don't know what you mean, the Americas. This is not Canada. This is not Mexico. This is not South America. Those are all the Americas.
It's America and it's the United States. The United States is the District of Columbia in a 10-mile square radius, and the state of every other.
Not really. Ohio is its own separate state.
In all due respect, in the state of any other state. I'm a state citizen, Ohio state citizen. There's a difference in the Americas and.
Okay, but that's not a difference that's going to make a difference during the trial. That's your objection at the very beginning. I've made my ruling, overruling it, and you can argue that, should you lose the case, in front of the Court of Appeals, or the Supreme Court of Ohio, or the United States Supreme Court, if it should either of the two Supreme Courts decide to take the case. But the issue in front of this jury is whether on June 5th of 2022, in Lake County, Ohio, you knowingly transported or had a loaded firearm in a motor vehicle in such a manner that it was accessible to the operator or a passenger without leaving the vehicle. That's the issue on count 1, and that's what the jury will be told. If the answer to that is true, beyond a reasonable doubt, then they can find you guilty of that charge. That's the code that I have to apply here. That's the code that my oath of office
The code conflicts
requires.
with my constitutional right on behalf of my
Okay,
state, my
and that's
person,
fine.
to be
And-
secured in
and-
their papers and their persons without search and seizure.
All right.
Unlawful search and seizure.
Okay, and I've overruled that objection.
That wasn't a.
Now, do you know anything about motions to suppress evidence?
That wasn't an objection, officer.
Okay.
But I have filed a motion to suppress on behalf of my state today.
Okay. All right. So before we set the case for a trial, then we'll set it for a hearing on the motion to suppress. And have you served a copy of that on the state?
Not yet.
And Foisel, can I take a quick look at that? Foisel, was there a communication that was intercepted here?
There's no wire down there. That's what you mean. There was communication shared after the fact by another division.
By somebody who would be called as a witness?
Correct.
That Mr. Dunham can cross-examine?
Yes.
All right, so the defense is claiming that the evidence was obtained as a result of an unlawful search. Good enough for you to prepare for a suppression hearing?
Yes.
Okay.
As long as it specifies which evidence.
Well, I'm assuming that the firearm, the marijuana, what evidence do you want
All the
suppressed?
evidence that this Willoughby Police Department has obtained was unlawful. I did not consent, and I reserve all rights.
Okay. So, I'm going to set this for a hearing on the motion to suppress. And I'm going to see how that goes in order to determine whether at the trial you should be able to represent yourself or your estate, and or whether I would have to appoint counsel and redo the motion to suppress and have counsel represent you at trial.
Why would the court redo my motion?
Because if I determine, I'm not getting the answers that I need in order to make that determination right now. Your appearance to me is that you are a knowledgeable individual, articulate individual, understanding individual, but my concern is that your focus on the UCC, the Americas, everything that you've been saying might not be hitting the nail on the head. And if you can't see the real legal issue,
I'm aware of the legal issue.
okay, and that's what I want to see how you perform.
My statement.
That's how I want to see how you perform on the motion to suppress, and if you perform well on the motion to suppress, then if I don't rule in your favor and there's still evidence going forward, then I may let you represent yourself. But if you convince me that you can't represent yourself effectively, then I won't let you represent yourself, because you've got to focus on the issue that I'm focused on, and that's the law, the revised code. That's what has to be focused on. Now, for the purposes of the suppression, it's certainly the Fourth Amendment to the U.S. Constitution that you need to be focused on. So we'll set this for a hearing on the motion to suppress. And is there anything else for today?
Not maybe more for today.
Okay, then my scheduler will send out a hearing notice. We have your address to send this to?
I believe that you have postal address.
Okay, do you have an email? Because
Yes.
anybody that,
Email for-
all attorneys and self-represented have to have an email, because that's how we send out things.
And yeah, my principal address should be on file.
But do you have an email? Because we don't want you to wait 3 days to get something in the mail. We want to send it to you by electronic mail so you get it instantly.
Are you able to mail it on behalf of my state? That way I have something black and white.
Well, that's not the way we normally do it. We're an electronic filing system, all electronic filing. We usually don't deal with paper filings, and our orders don't go out in paper; they go out electronically. And if you have an e-filing, if you register with the clerk, then you have complete access to the docket 24/7. You can file things electronically, and you don't even have to come to the courthouse to file them or stick them in the mail. It costs you nothing to file.
I just don't necessarily care for third parties and handling my information or my state's information.
Well, you understand, if you tell me that you will not deal with electronic filing, or...
No, it's not that I won't deal with it. It's more so a preference to have that black and white.
Okay, I understand you. I understand what your preference is, but I won't hear the objection. Well, the U.S. Postal Service did not deliver this because they didn't recognize my address or my name. You understand? When I send something out, the automatic presumption is that whoever I sent it to got it. I can't, if I had to put up with people saying, well, I didn't get this piece of mail, and therefore you can't proceed, I can't operate that way.
In all due respect,
Do you recognize the U.S. Postal Service as the agent of the court in serving you with papers?
Yes, I recognize the importance of the United States Postal Service.
No. Do you recognize the U.S. Postal Service as the agent of the court for delivery of any correspondence, any order notice to you?
Oh, yes, to my understanding, that's how it works.
So you consent to that, correct?
What do you mean? Do I consent to being...
If I stick something in the mail, am I going to get an objection later on? Well, they're not your duly constituted agent for delivery, and therefore I don't recognize what you sent to me.
I understand that I have that right, but I don't intend to play with the courts on behalf of my state.
Okay, it's good to hear that you don't want to play games, because I can tell you that I can only indulge this so long before I get the impression that games are being played, and I really don't have time to play games.
Trust me, in all due respect, I need to stay here on land and be there for my family. I have no warrant or no need to play any mind games.
Okay, now, you've not mentioned this, but you said stand here on land. You're not going to claim that this is an admiralty court, are you? Or that admiralty law has anything to do with this case? You're not going to object to the fringes on the U.S. flag behind me?
Admiralty law is statutory law, in all due respect to the court, but to save the integrity of the court, as was mentioned in the municipal court, I will refrain from using those terms in front of a jury that might not be competent of what that really means, because it really just means statutory law.
Okay, so the word admiralty will never come up in front of the jury, correct?
I understand that.
Okay. You know what I mean
It won't.
by admiralty.
It won't.
Okay. All right. So what is the address that physical correspondence, is it 135 Chestnut Lane, J323 in Richmond Heights, 44143?
Yes, that's the principal address.
Okay. All right, we'll send you the hearing notice to that address. It'll also be online so that you can actually check the docket, and it'll be online too. Anything further from the state?
No, Your Honor.
Mr. Dunham, anything further?
My state has nothing further to say.
All right. We're adjourned.
All rise.
Thank you, sir.
Let's go.
October 19th.
Posted 10,000, 10%. Yeah, yeah. Oh, that was I just always bring it up. Thanks. I just always include the OR when I put it out, just because it's.
But these are the conditions you would have. It's just the same conditions you've been found throughout this entire time. But you're just re-agreeing. Okay? So it's, you have to stay in constant contact with your attorney. So if Warren calls you, you have to call back, or pick up your phone. You have to appear in all proceedings. After today, it's going to be your pre-sentence investigation and your sentencing. You have to report changes in address or phone number. That's really important because otherwise nobody can contact you. You can't reside or travel within Lake County. And do you live in Lake County? Yeah. Okay. So outside of Lake County, we'll talk about the Georgia thing again. Okay. When is that taking place? December. Okay, so it's going to be fine. You'll probably be sentenced. It's our responsibility to keep you from your court, and then you can't use any drugs. You can't get any new charges. C does not apply to you. You have to stay in constant contact with Warren. Like I said, you can't drink within 24 hours of the hearing, and you can't violate any special conditions set by the court. So you are going to sign that address, phone number, and time of the sentencing.
It was good. It was kind of chill.
We're talking about the regards to this week.
All rise. This court of common pleas is now in session. The Honorable Eugene A. Lucci presiding.
May you be seated? do you pronounce your name, Matisse or Mattis?
Matisse.
Matisse.
Yes.
You're on the record. This is case number 22 CR 000654, State of Ohio versus Donald E. Matisse. Mr. Matisse is in court, represented by counsel. Assistant Public Defender Billy Kilmeyer, representing the State of Ohio, is Assistant Prosecuting Attorney Michael Fife. Mr. Matisse, you are charged in a one-count information filed by the Lake County Prosecuting Attorney on September 8th, 2022. The charge is improperly handling firearms in a motor vehicle, felony 4, with a forfeiture specification for the pistol and related accessories. It's my understanding you wish to plead guilty as charged, giving up your right of indictment. Is that your understanding as to what you want to do here today?
Yes, Your Honor.
You understand that this charge carries a maximum penalty of 18 months in prison, maximum fine of $5,000, and that you would forfeit the Smith & Wesson pistol, ammunition, magazine, and the laser.
Yes, Your Honor.
You understand you have the right to have the Lake County Grand Jury consider the evidence as presented by the prosecuting attorney, and for the grand jury to determine the charge or charges. In doing so, they could land on the same charge we have here. They could charge you with something more, something less, or nothing at all. The point is, it's totally up to the grand jury. Do you understand that?
Yes, Your Honor.
Have you discussed with your attorney the waiver of your right of indictment and a plea of guilty as charged to the prosecutor's information?
Yes, Your Honor.
And has he answered all of your questions to your satisfaction about that topic?
Yes, Your Honor.
Do you give up the right of indictment?
Yes, Your Honor.
I'm going to hand you a document called Waiver of Indictment. Make sure you've read it. Make sure you understand what it says. Make sure you agree with what it says. And if you sign it only because that's what you want to do.
Your Honor, I've witnessed Mr. Matisse sign his waiver of indictment here in open court and on the record. I have also signed it and moved to the prosecutor.
County, may I approach?
Yes. So I have the waiver of indictment signed by Mr. Matisse in open court, witnessed by both attorneys. I will make it part of the record in the case. So before I can accept your plea of guilty to this charge, I have to determine if you know and understand the rights you are giving up, the consequences of a guilty plea, and that you are entering this plea of guilty of your own free will. How old are you?
45.
How far did you go in school?
I have a GED.
And do you have the ability to read, write, and understand the English language?
Yes, Your Honor.
Do you hold any kind of state-issued occupational license or certification?
No, Your Honor.
Are you a U.S. citizen?
Yes.
Are you currently under the influence of any drugs, alcohol, or medication of any kind?
No, Your Honor.
Have you taken any within the last 48 hours?
No, Your Honor.
Have you ever been medicated, hospitalized, or treated for any mental illness in your life?
No, Your Honor.
Correction?
No, Your Honor.
Okay. Have you received a copy of the information and read the charge?
Yes, Your Honor.
Do you understand the charge?
Yes, Your Honor.
You can just say yes or no, it's fine. Did you discuss the charge with your attorney?
Yes.
Did he answer all of your questions to your satisfaction about the charge?
Yes.
Do you agree that the charge describes what you did?
Yes.
And do you wish to plead guilty to that charge and the forfeiture specification attached to it? I've been handed a 4-page document called Written Plea of Guilty. You probably went over this document with your attorney before we started the hearing. Is that correct?
Yes.
And did you read this document?
Yes, sir.
Do you understand it?
Yes.
Did you discuss this document with your attorney?
Yes.
Did he answer all of your questions to your satisfaction about the document?
Yes.
Do you agree with what it says?
Yes.
And do you wish to sign it?
Yes.
I'm going to go over the charge you are proposing to plead guilty to so that we are all on the same page. Count 1 says that on June 18th of 2022, in the city of Willoughby in Lake County, Ohio, you knowingly transported or had a loaded firearm in a motor vehicle in such a manner that the firearm was accessible to the operator or a passenger without leaving the vehicle. That's called improperly handling firearms in a motor vehicle. It's a felony of the 4th degree. It's in violation of Revised Code Section 2923.16b. Do you understand that charge?
Yes.
And is that the charge you wish to plead guilty to in this case?
Yes.
Attached to it is a forfeiture specification that says that you had in your possession at the time of the offense certain instrumentalities of the offense, and you would forfeit the items on that basis. The item being a Smith & Wesson SD-40 VE-40 caliber semi-automatic pistol, serial number FXA0987, a Defense Tech laser, a magazine, and ammunition. Do you understand that?
Yes.
And do you wish to plead guilty to that?
Yes, sir.
Do you understand if you plead guilty to the charge, you are admitting you committed the crime?
Yes.
Do you understand that if you had any defense to the charge, you give up that defense by pleading guilty?
Yes.
You understand by pleading guilty, you are giving the court the power to sentence you immediately.
Yes, sir.
You understand that any rulings previously made by this or any other court on this case prior to this moment would not be appealable because you're pleading guilty now.
Yes.
You have certain trial rights. You're giving them all up by pleading guilty. I'm going to explain it to you one at a time. I need to make sure that you know and understand you have these rights and that you're voluntarily giving up these rights. As I explain your rights to you, if you have any question about what I'm saying or if you need a better explanation, you need to speak up and let me know. Otherwise, I will assume you understood and answered the question that I asked you. Fair enough?
Yes.
You don't have to plead guilty. You have a right to have a trial to determine whether you're guilty of any crime. That trial would automatically be by a jury in this court unless you decided you wanted a non-jury trial. A non-jury trial is a trial where you want the judge not only to make all of the decisions throughout the case, but you want the judge to make the ultimate factual determination in the case whether the state can prove your guilt beyond a reasonable doubt. Do you understand that?
Yes.
Do you understand that with a trial, you have the ability to test every aspect of the state's case, both factual and legal?
Yes.
You understand that with the jury trial, the jury makes the decision, I don't, whether the state has proved its case against you. Furthermore, it takes all 12 jurors to agree that you're guilty. before it's even possible for you to be convicted. Do you understand that?
Yes.
The state of Ohio is required to prove your guilt beyond a reasonable doubt. If the state failed to prove even one essential element of a particular charge beyond a reasonable doubt, you could not be convicted of that particular crime. Your plea of guilty provides the court the entire factual and legal basis upon which to convict you and sentence you, and by your plea you are relieving the state of any obligation to prove anything, let alone prove it beyond a reasonable doubt. Do you understand that?
Yes.
You have the right to confront your accusers, meaning to have your attorney question all of the state's witnesses under oath in front of the judge and jury. Do you understand that?
Yes.
You have the right to use the subpoena power of the court to compel witnesses you need to come here to testify for you, especially witnesses who are reluctant to come to court, out of state, or incarcerated someplace. I can get them here for you. Do you understand that?
Yes.
You have the right to tell your side of what occurred here and testify in your own defense, or you could refuse to testify. It's one way or the other, but it is your choice. No one can compel you to testify if you didn't want to, and if you chose not to testify, that could not be used against you to prove that you were guilty. In fact, the prosecutor could not even comment on your silence to infer you might be guilty, have something to hide, maybe have a prior conviction. The jurors would be told you have that constitutional right not to take the stand and testify. We would select only individuals to serve as jurors in your case who answer under oath during jury selection that they will uphold that right. Do you understand all of that?
Yes.
You understand that if you were not pleading guilty today, you would always be represented by an attorney at law throughout this case, free of charge to you, paid for by the taxpayers.
Yes.
You understand that if you were not pleading guilty today, you could appeal any of the decisions I would make throughout the case. You could appeal the jury's verdict. You would have a free transcript typed up of everything that was said or done in this court, so you can demonstrate to a higher court any mistakes made here to get those mistakes corrected, and a free attorney to handle that appeal for you. Do you understand all of that?
Yes.
Do you understand a plea of guilty is a complete admission of guilt?
Yes.
Do you voluntarily give up all the rights that I just explained to you and wish to have this court accept your plea of guilty to count 1, improperly handling firearms in a motor vehicle, felony 4, and the forfeiture specification for the pistol and related accessories?
Yes, Your Honor.
Are you now, or were you at the time of this offense this past June, been on parole, post-release control, community control sanctions, or probation to any court anywhere?
No, no, Your Honor.
Have you ever been to prison in your life?
Yes.
How many times?
1,
And what year did you go?
1997.
And what court?
It was Cuyahoga County.
Okay. And what was the crime of conviction?
Felonious assault, aggravated robbery. I think that was it.
And were you given an indefinite sentence?
I had,
Like 4 to 25, something like that?
yeah, but it was yes.
Okay. How much time did you actually serve?
I came home January 09. Like 11 and a
Okay,
half
so
years.
you were in for roughly 10 years?
About 11 and a half.
11 and a half, okay. And do you have any other felony convictions on your record other than the ones for which you were sent to prison that time you mentioned?
Yes, sir. Yes.
And what kind?
Improper handling of a firearm.
Okay. Now, I take it this was a negotiated plea rather than weapons under disability?
Correct, Your Honor.
And you understood what I just said, right?
Yes.
Because the robbery and felonious, you'd be under disability, which is a higher degree offense. It's an F3 as opposed to the F4, and I just wanted to know if this was a negotiated plea. So you understand by pleading guilty, you are voluntarily giving up your liberty for whatever length of time I sentence you to prison, jail, or community control.
Yes, Your Honor.
And you understand in this case, I can send you to prison for 18 months. If I did send you to prison, 6 months would be the minimum, and it would be a whole number of months between 6 and 18, and I can fine you up to $5,000. You understand you would forfeit the pistol, laser, mag, and ammo. You understand that while in prison, you may be eligible for, be offered, and be able to earn some credit against prison time to be served by engaging in educational, vocational, or rehabilitational programming offered to you for that purpose. Prison credit is normally capped at 8% of time to be served, or a certain number of days according to the regulation. Do you understand that? Upon your release from prison, you could be on post-release control, PRC, in the discretion of the Ohio Adult Parole Authority for a period of up to 2 years. They give you rules, you violate their rules, they can return you to prison for up to 9 months in this case, even for one violation. All of that time is already part of the sentence. They don't have to bring the case back through this court in order to administratively impose additional time. Do you understand that? Further, if your violation of PRC is a new felony, the judge in a new felony case, in addition to sending you to prison on the new case, can send you back to prison on this case for the greater of 1 year, whatever length of time remains unexpired on that potential 2 years of PRC, and all of that time is already part of the sentence. They don't have to bring the case back through this court in order to judicially impose additional time. Do you understand that?
Yes.
By the way, on that imprisonment that you mentioned earlier, how long were you on for parole?
I'm not sure.
And it was parole, right? Not
Yes,
post-release
it was
control?
parole, yes.
Okay.
I'm not sure, but I think it was close to 3 years.
Okay, and you completed parole without violation?
Yes.
So you understand that if I chose not to send you to prison, I would impose a community control sentence that could last for up to 5 years. As part of the community control sentence, you'd have to abide by all probationary conditions that I would establish for you in the case, which could include time in the local jail, fine of up to $5,000 I mentioned, abstinence from alcohol and drugs of abuse, periodic screens to monitor your compliance, any treatment I determine you need, substance abuse or mental health, community service, the forfeiture that I mentioned, a no contact order, anything I determine you need to do. Do you understand? You would be required to perform exactly what I tell you to do, exactly how I tell you to do it.
Yes, Your Honor.
If you fail to do so, you'd be brought back before me on a probation violation. I will conduct a hearing. If I determine that you did violate your community control sanction, I can extend the period of time that you're on community control for up to that 5-year maximum. I can increase the nature and severity of the other conditions under the community control, meaning more time in jail, more treatment, more things to do, or I can terminate community control altogether and just send you to prison for 18 months. Do you understand that? You understand that you are under a firearms disability, both state and federal, whereby you cannot purchase, own, possess, or use firearms or ammunition for firearms. That's both state and federal. You understand that?
Yes.
You understand that there are other disqualifications that accompany a conviction of this sort. If I were to send you to prison, you could not vote from prison. In order to regain your ability to vote, you would have to re-register upon your release from prison. You cannot serve as a juror while on community control sanctions or on post-release control, where if the state is a party to that case, because you would still have an active case with the state of Ohio itself, and you cannot hold any position of public honor or trust. Do you understand that?
Yes.
In addition to the fines, the fine and the forfeiture that I mentioned, you understand that I will order you to reimburse the government the cost of confinement, community supervision, any treatment, and court costs.
Yes.
And do you understand the cost of confinement Also includes transportation costs between the court, the jail, and the prison institution.
Yes.
You understand I will enter a judgment against you for the costs of prosecution.
Yes.
If you fail to pay that judgment or timely make payments on a payment plan approved by the court, and you are serving a community control sentence rather than a prison term, you may be able to substitute community service to work it off. By local rule, you'd work it off at the rate of $10 per hour. Each hour of work performed reduces the judgment by that amount. Do you understand that?
Yes.
You understand a failure to pay all fines and costs in full can result in the state blocking your motor vehicle license plates until they are paid in full. You understand no promises have been made by the court, the prosecutor, your attorney, or anyone as to what I will do when it comes time for sentencing.
Yes.
You understand that no one can promise you what I'll do at sentencing because as I sit here, I don't even know what I'll do.
Yes.
And Mr. Fife, has the state of Ohio promised Mr. Matisse anything in this case
No, Your Honor, the state would request a pre-sentence report.
other than the charge, which is a negotiated plea?
Correct. Nothing, no promises, Your Honor. Thank you.
And Mr. Matisse, did you hear and understand what the prosecutor just said?
Yes.
So the prosecutor said that he has made no promises to you as to what he would recommend as far as a sentence goes. Is that correct?
Yes.
Has anyone else made any kind of promises or threats to you in order to get you to plead guilty? Are you entering this plea freely and voluntarily?
Yes.
Have you told your attorney everything you considered important in this case?
Yes.
And when I say your attorney, I mean not only Mr. Kilmeyer, but also Ms. Tuttle or any of the other public defenders who who touched this case or with whom you've had any kind of consultation with.
Yes.
And have you had enough time to discuss what you're doing in this case with your attorney?
Yes.
Although this may be your attorney's recommendation for you to plead guilty to this charge and the specification, is this your own decision and voluntary act to do so?
Yes.
Has your attorney done everything you've asked him or her to do for you in this case?
Yes.
And are you completely satisfied with the legal representation provided by your attorneys, Billy Kilmeyer and Lauren Tuttle?
Yes.
And Mr. Fife, what would the facts show if the case went to trial?
Thank you, Your Honor. Had this case proceeded to trial, the facts would show that on June 18th of this year in Willoughby, Lake County, Ohio, the police conducted a traffic stop upon the defendant's vehicle. Police subsequently searched that vehicle and located a loaded Smith & Wesson SD-40 VE 40 caliber semi-auto pistol with serial number FXA0987 that was located under the driver's seat. That pistol had a magazine loaded with 14 rounds. There was not a bullet in the chamber. There was also a Defense Tech laser equipped on the firearm. The defendant did acknowledge to police that he knew that the firearm was there, and that firearm was sent to the Lake County Crime Lab where it was confirmed to be operable. Thank you.
And Mr. Matisse, did you hear and understand everything the prosecutor just said?
Yes.
And is everything he said true?
Yes.
What is your plea to count 1, improperly handling firearms in a motor vehicle, felony 4?
Guilty.
Your plea to the forfeiture specification.
Guilty.
I'm going to hand you that 4-page document we talked about earlier, the written plea of guilty. Make sure you've read it. Make sure you understand what it says. Make sure you agree with what it says. And if you sign it only because that's what you want to do. I've made my markings on this document in red so you can easily tell what I've done to it since you last saw it.
witness, Mr. Matisse, signed his written plea of guilty here in open court and on the record. I have also signed it and handed it to the manager.
May I approach, Your Honor?
Yes. I have the 4-page document, written plea of guilty, which has been signed by Mr. Matisse in open court, witnessed by both counsel. I have added my signature to the judgment entry at the end of the document, and I will make it part of the record in the case. Record should further reflect that Donald E. Matisse was here in open court. I informed Mr. Matisse of all of his constitutional rights. He's made a knowing, intelligent, and voluntary waiver of those rights. I find he understands the nature of the charge, the effect of the plea, as well as the maximum penalty which can be imposed. Finding it to be knowing, intelligent, and voluntary, I accept his plea, and I find him guilty as charged. Count 1, improperly handling firearms in a motor vehicle, felony 4, revised code 2923.16b, and the forfeiture specification attached to it. I'm going to refer you to the Lake County Adult Probation Department for a pre-sentence investigation and report. Do you abuse alcohol or do you use illegal drugs?
Smoke marijuana.
And when was the last time you smoked marijuana?
Almost a week ago.
All right. And I'll do a drug and alcohol evaluation with a brief mental assessment. And you understand that smoking marijuana is still a crime. Marijuana is still illegal in the state. You understand that?
Yes.
Any other purposes for referral?
Your Honor, just one very briefly. Mr. Matisse does have a trial he may have to attend in Georgia in early December. Should he not be sentenced by then, I just wanted to put the court on notice that he may be requesting in the future through his probation officer who does his report to permission to leave the state. It is not a trial for which he has any charges. It is for the murder of his son, and they may need his attendance at that trial.
Okay. You still live at 726 East 347th Street?
Yes.
That's in East Lake. Do you have a land phone line there, a wired line?
Just my cell phone.
And what's your cell phone number?
440-668-5637.
And sentencing will be held in this court on Monday, November 7th, 2022 at 9:15 a.m.
Judge, did you say 7th or 2nd?
7. The day before Election Day. I'm printing out the referral for pre-sentence investigation. You're to take your copy and go directly from the court to the 3rd floor of the sheriff's office. That's the building to the north of here. That's the location of the court's adult probation department. They'll do an intake interview. They'll take a urine sample for analysis. If you test positive for alcohol or any substance of abuse, except for a lower reading for the marijuana, I'll revoke your bond and you'll stay in jail until sentencing. Understood?
Yes.
And what was bond set at?
It was 10,000, 10%.
Any reason not to continue it?
No reason not.
So it was 10,000 cash surety, 10%?
Correct, yes.
And I have bond conditions that have already been signed by the defendant. Anything further from the state?
No, Your Honor, thank you.
Defense?
No, thank you, Your Honor.
All right, I'll see you November 7th.
Thank you, Your Honor.
We're adjourned.
Court of Common Pleas is now in session. The Honorable Eugene Lucci presiding.
May be seated. This is case number 20 CR 000688, State of Ohio versus Albert C. Sanger III. Mr. Sanger is in court, represented by counsel, Assistant Public Defender Billy Kilmeyer, representing the State of Ohio, representing the Lake County Adult Probation Department is Probation Officer Kaylee Warren. The defendant was here on January 20th of 2021. He pled guilty to an amended lesser included offense to count 1, being attempted domestic violence, felony 5. I referred him for a pre-sentence investigation and report, set a sentencing date, and continued his bond. I sentenced the defendant on February 22nd of 2021, adopting a joint recommendation for community control to 2 years of community control sanctions with 60 days in jail, credit for 4 days. I gave him a delayed start, afforded him the opportunity to substitute house arrest on GPS and Scram with privileges for work, school, medical, and probation purposes. He was to complete the Laurelwood Intensive Outpatient Treatment Aftercare, following all recommendations, abstinence screens for 12-step program meetings, full employment or school, mental health assessment and counseling as recommended, 1 doctor, 1 dentist, 1 pharmacy, take all medicines as prescribed, perform 100 hours of community service, and undergo anger management counseling. I told him a violation would result in a 12-month prison term. I notified him of the potential and consequences for violation of post-release control. I explained the 8% credit, substituting community service for costs, and the state block on the motor vehicle registration. The defendant returns to the court today on a probation violation. The probation violation is documented in an affidavit signed by Probation Officer Warren on September 12th of 2022. The officer alleges 3 violations. She says that the first violation is a violation of Rule 8, which requires sobriety. She says the defendant tested positive via instant stick for cocaine and marijuana on a urine screen collected on September 12th, 2022. She alleges 2 violations of Rule 1, which requires obedience to the law. She says that on September 9th, 2022, the defendant was charged with F5, aggravated possession of drugs, by Wickliffe PD. The arraignment was set for Willoughby Municipal Court, case number 22, CRA 2056, on September 14, 2022. She alleges a second violation of Rule 1 and says that the defendant was charged on September 9th, 2022 with possession of drugs, misdemeanor 1, possession of marijuana, minor misdemeanor, and drug paraphernalia, minor misdemeanor by Wickliffe PD, with the arraignment set on September 14, 2022 in case number 22 CRB 2057. The State of Ohio filed a motion to terminate community control on September 12th, 2022. I've met with defense counsel and probation officer in chambers prior to coming into the courtroom, and I am informed, Mr. Sanger, that you wish to give up your right to a probable cause hearing, the purpose of which is for the court to determine whether there's a reason to continue to hold you to answer for the violation. He tells me you wish to give up your right to a final hearing whereby the court would require evidence to its satisfaction that you did violate in 1, 2, or all 3 ways alleged in the officer's affidavit, and if I so find, you're entitled to a sentencing hearing. Do you understand these hearing rights?
I do, Your Honor.
You understand that your exposure here is that 12 months in prison I told you about when I took your plea and when I sentenced you?
I do.
And have you discussed with your attorney the waiver of your probable cause hearing, the waiver of your final hearing, a plea of guilty to the violations, and any other options you may have at this point?
I have.
And has he answered all of your questions to your satisfaction about that topic?
Yes.
So do you give up the right to a probable cause hearing?
I do.
Do you give up the right to a final hearing?
I do, Your Honor.
And what is your plea to the first violation, testing positive for cocaine and marijuana?
Guilty.
And by the way, I was informed that both of those cases, the 2056 and the 2057, were resolved in the Willoughby Municipal Court, and the defendant pled guilty to an M1 possession of drugs, correct?
Yes, Your Honor.
All right. And you were sentenced to 60 days in jail on that,
I was.
correct? All right. And so I'll just combine both of the next 2 violations into one. And what is your plea to being convicted of M1 possession of drugs?
Guilty.
Court finds that the defendant has knowingly, voluntarily, and intelligently waived his rights to a probable cause and final hearing, has entered a plea of guilty to 2 violations. Court finds the defendant guilty of both violations, using cocaine and marijuana, and being convicted of possession of drugs, M1, and determines that they are both non-technical violations because they are crimes, even if committed by someone not on community control. Any reason not to proceed to sentencing, Mr. Kilmeyer?
No reason not to proceed.
Go ahead.
Thank you. Just very briefly, I have had multiple opportunities to speak with Mr. Sanger since this violation has been filed, and in his year and roughly 7 months that he has been on probation with this court, he's been very busy with treatment. He went through and completed Laurelwood. He's been attending an average of 2 AA meetings per week. He was engaged in aftercare and counseling at Signature Health. His problem, Your Honor, has never been cocaine. It has always been alcohol, and he, for a long period of time, had that under control. I think he had about 2 years of total sobriety before picking up this charge. Treatment is something that he knows how to do. He knows how to be successful at it. He's done it before. So I would ask that this court impose as a sentence the jail treatment program while he is serving that 60 days out of Willoughby with aftercare mandated. And I believe that will give him a good opportunity to show to this court again that when he is done with JTP and moves on to an IOP or whatever aftercare is recommended by the jail treatment program, he knows how to be successful at it. He's done it before. He's worked very hard to maintain his sobriety, as well as his relationships. He lives with his girlfriend, Christy Starr, who I've also spoken to while these cases were pending. She's a good support system at home. She supports him in his sobriety, and she will continue to do so when he is released from Lowell County Jail. So again, Your Honor, I have asked the court to impose an additional sanction on his 60-day sentence for referral to the jail treatment program and extend his probation so that his aftercare can be monitored. Thank you.
Mr. Sanger, do you have anything to say before I sentence you?
Yes, Your Honor. Just to let you know that I know that I screwed up and I have to own up to whatever, I did. I was sober for 2 years and things were really going good for me. And I think maybe that's a little of the reason why I might have relapsed, because I got scared. Stuff going too well. I'm not used to that. But I consider and make excuses or whatnot, but I have to own up to what ultimately what was happening.
The court's considered the record, the oral statements made, the pre-sentence report, my conference in chambers with defense counsel and probation officer, and the statements of the defendant and the defense counsel. I've also considered the overriding purposes of felony sentencing, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution, along with the public burden on governmental resources. I've considered the recommendations of the parties. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders, and using my discretion to determine the most effective way to comply with the purposes and principles of sentencing. I have considered all relevant factors, including the seriousness and the recidivism factors set forth in the statute. There's been no change in seriousness since the original sentencing. However, in terms of recidivism factors, there has been a change. Recidivism is more likely because of the rehabilitation failure. There is a pattern of substance abuse, and the offender refuses to apply the treatment tools previously given to him in his intensive outpatient treatment program that I ordered previously. In terms of making recidivism less likely, the offender acknowledges the problem and what led up to his misstep. The court will extend the community control sanction by 1 year to a total of 3 years. I'm imposing 60 days in jail concurrent with the Willoughby Municipal Court sentence in case numbers 22 CRB 2057 and 22 CRB 2056, whichever is applicable. You are to enter, participate in, and successfully complete the jail treatment program at the earliest opportunity. And following all recommendations and aftercare, the balance of the jail if there is any, after completion of the jail treatment program, will be vacated. All of the conditions previously ordered on February 22nd, 2021 remain in full force and effect, as if repeated entirely. A violation of this order will result in a prison term of 12 months. If you do end up in prison, post-release control is optional for a period of up to 2 years. They give you rules. You violate their rules, they can return you to prison for up to 6 months, even for one violation. All of that time is part of the sentence. Should the violation of post-release control be a new felony, in addition to going to prison on the new case, you can go back to prison on this case for another year. All of that time is part of the sentence. Is there anything further, Mr. Kilmar?
No, Your Honor.
Anything further, Kaylee?
I just have one question, Your Honor. In February, this case was released to 2/3. Would you like it to be 4/3 or continue on 2/3?
Well, if the jail treatment program recommends more than that, then go with the jail treatment program.
Understood. Thank you, Your Honor.
All right. Mr. Singer, any questions about what's expected of you?
I know what's expected from me, Your Honor.
All right, good luck.
Where did you get arrested? Did they take the ID?
Huh?
Did Wickliffe Police take the ID?
They answered. They said you saw it. So they took it. I didn't have it on me. That's the laptop, the purse. The laptop's on your mind, he's on your purse. Both those things belong to the girl Shannon. Purse and the laptop.
Well, you can't get the laptop, it wasn't yours.
Pardon?
The laptop was hers?
Yeah.
All right, you can't get that back.
How much do you want to watch this in the room where they took me out?
Pardon?
It was in the room they took me out?
Yeah, but if it's not yours, they can't give it back.
Well, how do I get her stuff back?
She has to.
So if she got rid of it, so I gotta go over and tell her again? Okay, all right.
We can ask for the ID.
Pardon?
Pardon? Can you hear you?
And the purse goes in the...
Yeah, she's got it. Should I
get all that? Okay.
I mean, tell her to call Wickliffe Police.
Okay, all right, yeah. I wonder if my ID was in her purse, maybe. So we have no idea what that was. I got some of my cyclists yesterday. I got some of my cyclists yesterday.
Oh, good.
Yeah.
Oh, good.
So she got one. So I think that was she doesn't do drugs. I do like that. She teaches voice complication. This is, she got still better.
Well, that's good.
Yeah. But 6 years I was sober, I told you about going back to that. I'll never be in jail. That nurse said that. I'll go back to the years, back to the things. I told her because I don't want to go to jail. Sort of heavy the way I live. I hate it. You know?
Yeah, well, you are too old for this.
Huh?
You are too old for
I
this.
agree. This, I want this guy to help me out too. And you know you're seeing the guy that go back to being sober. I did for 16 years. And he's happy and healthy. He did the right thing. I got to go back to him. My daughter went to be in law school. I got such a school. I just told them when they were kids, you know. They wouldn't want to go and bring their own issues to have which my kids. So it's all another song. To the rest of the thing, you know. But I was really good.
Pardon?
I don't think he's going to be 100% ready. Because the judge hears his stuff all the time. We've got some fun. They help you okay, find it. Backs of my divorce. My son died, I just been going on to Willie's. We each say from him. Everything happens for a reason, I say.
Yeah. That's a tough one.
Yeah. And then my daughter's from Major Place.
went to the same high school. Only it's not the same high school. So when I went there, there was no pool.
Yeah, me either.
Oh, there's now, they say.
Yeah.
Yeah,
You wouldn't recognize if you went there.
no,
Made a lot of changes.
right. Well, somewhere, wherever that pool is, that was when they had the, workplace, there was a garage there. So teach kids out of school, I was in Paris.
Yeah, that's,
And that was in 73 when I started.
yeah, I think that's, they still have that, but it's on like the other side,
Right, all right.
vocational.
My older sister graduated from 72, and she goes spend years every year. And there was a time capsule in front of the 910 building. I guess they opened it here recently. I'd
Yeah.
love to go, what was put in.
Yeah, I think they wait 50 years. That's
Yeah.
probably what they,
Yeah, well, that was like 72 that was there. I'd love to know where exactly it was in there. So I was part of it. I was active in school. I was on the big team at school.
yeah, like I said, you would not,
Yeah.
the two buildings, like the nine, they're still there, but they've added on and
All right, yeah.
they connected them differently. It's,
The guy that ran the big team, he thought I should go to law school. And then there was me plus a strength guy, and Tony Silva.
he's a nice guy.
Tony wanted me to go to law school.
Yeah.
Do you do Tony?
I knew who he was,
Oh, okay.
but I didn't, could be exaggerated. I knew two of his kids and that, and
Oh, okay.
can't think of his son's name.
The gay kid?
No, this guy's not good.
Oh, okay. Well, I heard he had a big son. These guys.
I can't think of the guy's name. Really nice guy,
Yeah.
but they're older now.
Right.
You know, they're,
Yeah.
and that's gotta be in her 60s.
Tony's wife was from Georgia. He met her in Florida.
Yeah, I never met her.
I grew up with the father, Priscilla Stanton. I grew up with Pete and Mary Jo. They're the owners, one, Pete's the owner. They both their daughters. And that was one about 2 years. And then Charlene and Kathy, their kids, and their son, like,
Yeah, they sold it like 2 years ago.
yeah. Yeah, I guess and that's, custom ones. They are sold.
Yeah, I don't know.
Yeah. And Pete's about to die, like my dad. Pete lives in Maple Grove still. No, actually, Maple House.
It's gonna bug me, I can't think of his son's name. But he was fun.
Tony's son?
Yeah,
I can't even think of it. I've never saw it.
he was really, really fun.
Yeah,
I haven't seen him in years.
yeah. They were a good family, good kids of both. I grew up in a nice neighborhood.
Yeah,
Broke right into it. My parents gave me everything in the world.
well, it's,
The best thing I ever did.
they're making a ton of changes on Mayfield Road now.
Yeah, I know. Yeah, one time I went to get a phone thing, and the guys told me to go to, place to get my phone looked at. He goes, where's the average? Some black guy from me, they had a story with people. I'm looking at them, okay, now we used to each other sometimes. There's no average on me. What are you talking about? Guess what? That was a big team when I was a kid. That was a school, or a gas station I worked at.
Yeah.
Where Arby's is, right next to Seacoast.
I'm trying to think where Arby's is out there.
And Lantern Nathan, right across, right next to the Silver Star, the funeral home, the Seacoast funeral home. The Seacoast funeral and, Arby's.
Oh, yeah.
And Master.
Yeah.
Place across the street from him.
Yeah, the Seacoast has been there forever.
Oh, yeah. But that's what it buried my dad. I went to Windsor Ski to see her. She lied, and her parents owned that.
Yeah, I went to school with his son.
They were good people.
Yeah,
They lived right up people, on a road called Catalan. Catalan. And if you're going.
well, the youngest son passed away.
Oh, yeah?
He had a heart attack or something. I want to say 5 years.
That's true, because that was a good family, they were good people.
Yeah. Well, the oldest son is the mayor now.
Right? Daughter, she's my friend. Glenn Hughes streets, Glenn Hughes.
Yeah, you're going way back now.
Yeah.
Delivering papers.
1914 or 1969. 1969, I do it at Glenn Hughes.
Yeah, they barely have a print edition. now.
Yeah, I know. I have 42 houses. That's incredible. Alcester, Algiers, Alcester, Algiers, Alcester, where's Algiers and Landerwood in Scotland. Yeah, you would get
Yeah. Well, it's such a throwback now.
Oh, yeah, they looked at their schools, or their school grades and everything else. So they got, you get pretty beautiful. Not a real good job for one.
Well, that was a tough job. Kids nowadays would do that.
Oh, yeah.
Guy got up at 5.
Yeah. And on Sundays, you had to stuff the newspaper. All the magazine, the funnies, and all that stuff. You had to, Sunday came with Jesus, and you had to put it together. Saturday night or something.
Yeah, that's going way back.
Oh, yeah. I always worked on. My whole life I worked hard. That's why I don't know why God made me flying. I enjoyed this review flying. I worked, I paid my child support, took care of my kids. The child support just for like $3, it was $1,300 a month. For 2 kids. That's in the 90s. God bless him. I did the right thing. Now I started he's still there, you know.
Who's it?
God, he's still there.
Yeah.
He took care of me, raising my kids and building me and that. I was doing the right thing. God took care of me. I quit doing it. He was punishing me for it. And that's okay. It's my own fault, you know. I'm the one that does stupid stuff. I can't wait till my daughter is over, you know.
It won't be long now if she's in law school.
Well, she's in 3rd year.
Yeah,
In the 3rd year.
it won't be long.
And she was smart. When she was a kid, she was smart. When they were kids, I have my kids in school and stuff. It's the homework. And I always made the girls breakfast because I left early to go to the car out. So I had breakfast food. We had to do the homework in the morning during breakfast before they got on the bus because those are the country, so they took the bus. So I'd help them with their homework every other night. Eat breakfast and have them with their homework. I didn't have to do that when I was a kid.
Yeah.
A lot of kids do better people than I was. And so far they are.
Well, that's,
Yeah. Their mom was good, you know. Amy's a big part. Amy was good. She shit on me and stuff, and that's why we got to broke up. But she's still good now. She's very good. And my daughter Leah, she wants to go with me on both sports scholarship. Baseball and basketball. She's 6'1".
oh, wow.
Yeah. Mom's got blue eyes. Pretty good.
Yeah, that is one.
Yeah. Married him out for 75 years.
Wow.
He thinks I'm full because I was married 7 times, you know. He was married 16 women all those years, so,
Yeah, God bless him.
yeah. And you know, they keep on taking out the worst windows and out. You get one of them, you're out there, look, every day, you did your work. Took care of that. He was born in 1927.
Not too bad, so. Good.
67 years old. I got a little mark on my shoe.
That's all right. They're fitting better than they were last.
Yeah, they're pretty better, yeah. Yeah, they're pretty better than I got on my wrist. I give my shoes. I give my shoes back. I buy a new job. They got a top coat on. A lot of time. Those look good. I never thought I would be in fashion.
We're on the record. This is case number 22 CR 000914, State of Ohio versus Rory E. Dean. Mr. Dean is in court, represented by counsel. Assistant Public Defender John Fatika, representing the State of Ohio, is Assistant Prosecuting Attorney Haley Gold. Mr. Dean, can you hear me okay?
Yes, Your Honor.
Mr. Dean, you are charged in a one-count information filed by the Lake County Prosecuting Attorney on September 8th, 2022. The charge is possession of cocaine. It's a felony of the 5th degree. Carries a maximum penalty of 12 months in prison, maximum fine of $2,500, maximum driver's license suspension of 5 years. Attached to it is a forfeiture specification for contraband and instrumentalities, being cocaine, glass pipes, and a pill. It's my understanding you wish to give up your right of indictment and plead guilty as charged. Is that your understanding as to what you want to do here today?
Yes, Your Honor.
And you can just stay seated. And it's further my understanding that you wish to go directly through sentencing once I accept your plea with a joint recommendation as to the sentence. Is that your understanding also?
Yes, Your Honor. But can I say one thing, sir?
Sure.
I have to apologize to you. You've tried to do me right before, and I've let you down. I apologize for that. I'm a drug addict. I have a girl from Signature who's going to give me into treatment, and I've been trying to put my life back together. I've sober once for 16 years. They're the best years of my life, so I have to get sober. I have to go back to meetings. I have to quit living this way. I don't want to die in prison, and unfortunately, I feel this way. So I hope you understand, and I'm going to do the right thing. I'll follow directions from the girl at Signature and the other people there.
Well, let me find out. What's the agreed sentence?
Your Honor, the agreed sentence is that he would get time served for 42 days that he spent in jail.
All right. And Mr. Dean, we'll do first things first, but you know, you didn't let me down. You let yourself down. My life goes on. Your life is the one that you are, you're addicted to drugs, and it's robbed you of a good life. And, you know, you're solely to blame for that. But, you know, I mean, I wish you would get sober. But the task at hand is whether I accept your plea of guilty to this charge, and then once I accept your plea, what the sentence is. You understand that?
Yes, Your Honor.
Now, you understand that you don't have to plead guilty to the prosecutor's charge. You have a right to have the Lake County Grand Jury consider the evidence as presented by the prosecuting attorney, and for the grand jury to determine the charge or charges. In doing so, they could land on the same charge we have here. They could charge you with something more, something less, or nothing at all. Do you understand that?
Yes, Your Honor.
And have you discussed with your attorney the waiver of your right of indictment and a plea of guilty to a prosecutor's information?
Yes, Your Honor.
And has he answered all of your questions to your satisfaction about that topic?
Yes, he's been excellent. He's tried to help me a lot.
All right. Do you give up the right of indictment?
Yes, Your Honor.
I'm going to hand you a document called Waiver of Indictment.
Okay.
Make sure you've read it. Make sure you understand what it says. Make sure you agree with what it says. And if you sign it only because that's what you want to do.
That's what we discussed the other day?
Yep.
We went through all this, Your Honor. Thank you. Here? Here?
No.
Yep. Excuse my signature. I'm sorry. I hate that.
That's okay.
attorney turn a sign waiver of indictment, Your Honor?
Yes. I will make the waiver of indictment, which has been signed by Mr. Dean in open court, witnessed by both attorneys, part of the record. Before I can accept your plea of guilty, I have to determine if you know and understand the rights you are giving up, the consequences of a guilty plea, and that you are entering this plea of guilty of your own free will. How old are you?
67.
How far did you go in school?
12th grade.
Do you have the ability to read, write, and understand the English language?
Yes.
Are you a U.S. citizen?
Oh, yes, sir.
Are you currently under the influence of any drugs, alcohol, or medication of any kind?
No, Your Honor.
Have you taken any within the last 48 hours?
No, sir.
And how long have you been in jail?
Since August 3rd.
August 3rd, all right. And you're serving out one of my sentences or a municipal court sentence?
May I explain, Your Honor?
Yes.
He's been in, I think, for a total of 54 days. He was sentenced to time served about a month ago. We did, at that time, the probation officer and myself did not understand that there was a warrant out at Willoughby Municipal Court. It's the new case that he got picked up on, but it was marked closed on the docket. When he went to get released, Willoughby picked him up, and that case got bound over. That's what we're hearing.
All right.
So he's been at the jail for 54 days. 42 are attributed to this news case.
Okay. So have you received a copy of the charge?
Yes, Your Honor.
Did you read it?
He's read it by his lawyer, read it to me, sir.
Okay. Do you understand?
I can't read it.
Okay. Do you understand it?
Yes, I understand.
Did you discuss the charge with your attorney?
Yes, I did.
Did he answer all of your questions to your satisfaction about the charge?
He's been excellent to me, Your Honor.
Okay. Do you agree that that charge describes what you did?
Yes, Your Honor.
And do you wish to plead guilty to that charge and the forfeiture specification attached to it?
Yes, Your Honor.
I've been handed a written plea of guilty consisting of 4 pages. Did your attorney read this to you?
Yes, Your Honor.
And do you understand it?
Yes, I did.
And did you discuss this with your attorney?
Every question I had, I asked him and he answered it to my knowledge.
All right.
Thank you.
And do you agree with what this document says?
Yes, Your Honor.
And do you wish to sign it?
Yes, Your Honor. Excuse my signature, Your Honor.
You can make an X. If I see you make the X, that works.
Okay, Your Honor. Thank you.
So the charge says that on August 3rd, 2022, in the city of Wickliffe, Lake County, Ohio, you knowingly obtained, possessed, or used cocaine, a Schedule II controlled substance. That's called possession of cocaine. It's a felony of the 5th degree. It's in violation of Revised Code Section 2925.11. Do you understand the charge?
Yes, Your Honor.
And is that the charge you wish to plead guilty to?
Yes, Your Honor.
The charge further states that at the time of the offense, you had in your possession cocaine, glass pipes, and a pill, which are contraband and/or instrumentalities of the offense, and you would forfeit those items. Do you understand that?
Yes, Your Honor.
Do you wish to plead guilty to that?
Yes, Your Honor.
You understand if you plead guilty, you're admitting you committed the crime.
Yes, Your Honor.
You understand by pleading guilty, you give up any defense.
Yes, Your Honor.
You understand by pleading guilty, I will sentence you immediately.
Yes, Your Honor.
You have certain trial rights. You're giving them up by pleading guilty. I'm going to go over them with you one at a time. I need to make sure you know and understand you have these rights and that you're voluntarily giving them up. Can you hear me okay?
Yes, Your Honor.
All right. So you understand you have a right to a trial to prove whether you're guilty or not. You understand that?
Yes, Your Honor.
You understand that can be a jury trial,
Yes, Your Honor.
and that by pleading guilty, you're giving up the right to any kind of trial, jury, or bench.
Yes, Your Honor.
You understand the state has to prove your guilt beyond a reasonable doubt,
Yes, Your Honor.
and that by pleading guilty, you're relieving them of that obligation.
Yes, Your Honor.
You understand you have the right to confront your accusers.
Yes, Your Honor.
You can question, your attorney can question all of them.
Yes.
You understand you have the right to use the subpoena power of the court to make witnesses come here for you.
Yes, Your Honor.
You understand you have a right to refuse to testify, and that refusal to testify cannot be used against you. It can't be used to prove that you are guilty. The prosecutor can't comment on your silence in order to prove that you were guilty, and the jury that we would pick in your case, if the case went to trial, would be told about that right to remain silent and that they couldn't use it against you. You understand all of that?
Yes, Your Honor.
You understand that if you were not pleading guilty, you would always be represented by an attorney throughout this case, free of charge to you?
Yes, Your Honor.
You understand if you were not pleading guilty, you could appeal any of my decisions and the jury's verdict to get any mistakes corrected, and an attorney to handle that appeal for you, and all of that would be provided to you free of charge.
Yes, Your Honor.
You understand a plea of guilty is a complete admission of guilt.
Yes, Your Honor.
Do you voluntarily give up all the rights that I just explained to you and wish to have this court accept your plea of guilty to 1 count of possession of cocaine, felony 5?
Yes, Your Honor. Thank you.
You understand in this case I can send you to prison for 12 months. 6 months is the minimum prison time if I were to send you to prison, and I can fine you up to $2,500.
Yes, Your Honor.
You understand I can suspend your driver's license for up to 5 years.
Yes, Your Honor.
You understand you would forfeit the items in the specification.
Yes, Your Honor.
You understand if I chose not to send you to prison, I can place you on probation, community control for up to 5 years.
Yes, Your Honor.
And if you fail to abide by whatever probationary conditions that I would establish for you, I can send you to prison for 12 months or keep you on probation for up to 5 years and make you do other things, including more treatment.
Yes, Your Honor.
Understand that in addition to any fine and the forfeiture, I can order you to reimburse the government the cost of confinement, supervision, treatment, and court costs.
Yes, Your Honor.
And that the cost of confinement also includes transportation costs.
Yes, Your Honor.
And you understand I will enter a judgment against you for the costs of prosecution,
Yes, Your Honor.
and any failure to pay all fines and costs can result in the state blocking your license plates. You understand that?
Yes, Your Honor.
Do you understand all the potential penalties?
Yes, Your Honor.
Any question at all as to what can happen to you?
No, Your Honor.
You understand no promises have been made by anyone as to what I will do?
Don't worry, it's not anything, sir.
And you understand I don't have to follow the joint recommendation?
Yes, Your Honor.
Has anyone else made any promises or threats to get you to plead guilty?
No, Your Honor.
Are you entering this plea freely and voluntarily?
Yes, Your Honor.
Have you told your attorney everything?
Yes, I have.
Have you had enough time to discuss what you're doing in this case with your attorney?
Yes, Your Honor.
Although this may be your attorney's recommendation, are you pleading guilty because that's what you want to do of your own free will?
Yes, I want to.
Has your attorney done everything you've asked him to do for you?
Yes, he has. He's been superb.
Are you completely satisfied with John Fatika's services?
Yes, sir.
Ms. Gold, what would the facts show?
The facts would show that on or about August 3rd, 2022, in Wickliffe, Lake County, Ohio, officers were called to the Plaza Motel and gained consent to enter the defendant's room. Within the room, officers located suspected cocaine, a pill, and glass pipes. The suspected cocaine was sent to the Lake County Crime Lab, where it tested positive for 0.10 grams of cocaine, a Schedule II controlled substance.
Mr. Dean, did you hear and understand what the prosecutor said?
Yes, Your Honor.
Is everything she said true?
Yes,
What is your plea to one count of possession of cocaine, felony 5?
Justice, Your Honor.
Your plea to the forfeiture specification.
Justice, yes, I understand.
I'm going to hand you the written plea of guilty document we talked about earlier. That 4-page document, make sure you've read it, make sure you understand what it says, make sure you agree with what it says, and if you sign it only because that's what you want to do. My markings are in red, so you can easily tell what I've done to it since you last saw it.
This is what we went over last week. Judge, my picture of the assessor.
Okay.
Just want to make sure. Just sign it.
Right here.
That's all right. I return the signed written plea of guilty, Your Honor.
Yes? The court will sign the judgment entry at the end of the written plea of guilty, which has been signed in open court by Mr. Dean, witnessed by Mr. Fatika, Ms. Gold. I will make the written plea part of the record in the case. Rory E. Dean was here in open court with Attorney John Fatika. I informed Mr. Dean of all of his constitutional rights. He's made a knowing, intelligent, and voluntary waiver of those rights. I find he understands the nature of the charge, the effect of the plea, as well as the maximum penalty which can be imposed. Finding it to be knowing, intelligent, and voluntary, I accept his plea and find him guilty as charged. Possession of cocaine, felony 5, revised code 2925.11, and the forfeiture specification attached to it. Mr. Dean, do you have anything to say before I sentence you?
No, Your Honor.
Anything to say?
Your Honor, only that the state asks that Your Honor give the defendant 42 days credit with no further community control sanctions.
I just want to put on the record that we're appreciative of the way this case was handled in the prosecutor's office, Ms. Gold and Ms. Linden. We also appreciate the scheduling of this hearing. It was bumped further ahead. And again, we appreciate the consideration.
Consider the record, oral statements made, court's prior history with the defendant, the statements of the defendant and counsel. I've considered the overriding purposes of felony sentencing. I've considered the need for incapacitation, deterrence, rehabilitation, and restitution along with the public burden. I've considered the joint recommendations of the parties. I have reasonably calculated the sentence to achieve the overriding purposes and to be commensurate with and not demeaning. I've considered the relevant factors, including seriousness and recidivism. The court will adopt a joint recommendation. I'm imposing 42 days in jail with credit for 42 days, concurrent with any other sentence. Anything further from the state?
Nothing further, Your Honor.
Defense?
Just one more thing. Mr. Dean believes that his identification card was confiscated out of the hotel room on August 3rd. We'd ask that the court consider putting in the order that if the Wycliffe police do have the ID card, that they allow Mr. Dean to pick it up. He was on a waiting list at Signature Health, and you can't get his own apartment without that.
All right. And so any identification card in the possession of the police shall be returned to the defendant.
Thank you, Your Honor.
All right. We're adjourned. Good luck.
get out today. You have
And I took care of that little problem over here.
Perfect.
I flip that baby right off.
Send me a phone call.
Okay. Ugly. That's not what it is.
Court of Common Pleas is now in session. Your Honorable Eugene A. Lucci presiding.
May be seated. Tony, something happened with the remote desktop. I'm gonna restart it and see. you wish to give up your right of indictment and plead guilty as charged? Is that your understanding as to what you want to do here today? Oh, there's an indictment here, not an No, I never talk about when the offense occurred. I always talk about when the information was filed. Okay. Tucker, you understand that you have the right to have the Lake County grand jury consider the evidence as presented by the prosecuting attorney and for the grand jury to determine the charge or charges. In doing so, they could land on the same two charges we have here. They could charge you with something more, something less, or nothing at all. The point is, it's totally up to the grand jury. Do you understand that? And have you discussed this decision about waiving indictment and pleading guilty by way of prosecutor's information with your attorney? And has she answered all of your questions to your satisfaction about that topic? Do you give up the right of indictment? And you a document called waiver of indictment. Make sure you've read it. Make sure you understand what it says. Make sure you agree with what it says. And if you sign it only because that's what you want to do. in the case. So before I can accept your plea of guilty to this charge, I have to determine if you know and understand the rights you are giving up, the consequences of the guilty plea, and that you are entering this plea of guilty of your own free will. How old are you? How far did you go in school? And do you have the ability to read, write, and understand the English language? Do you hold any kind of state-issued occupational license or certification? Are you a U.S. citizen? Are you currently under the influence of any drugs, alcohol, or medication of any kind? Have you taken any drugs, alcohol, or medication of any kind within the last 48 hours? Have you ever been medicated, hospitalized, or treated for any mental illness in your life? Have you received a copy of the information and read the charges? Do you understand the charges? Did you discuss those charges with your attorney? Did she answer all of your questions to your satisfaction about the charges? Do you agree that these two charges describe what you did? And do you wish to plead guilty to the two charges? I've been handed a 4-page document called Written Plea of Guilty. You probably went over this document with your attorney before we started the hearing. Is that correct? And did you read this document? Do you understand it? Did you discuss this document with your attorney? Did she answer all of your questions to your satisfaction about the document? Do you agree with what it says? And do you wish to sign it? says that on June 23rd, 2022, in the city of Mentor, Lake County, Ohio, you knowingly obtained, possessed, or used methamphetamine, a Schedule II controlled substance. That's called aggravated possession of drugs. It's a felony of the fifth degree. It's in violation of Revised Code Section 2925.11 and Division B controls when it comes to determining whether I should impose prison. Do you understand that charge? And is that the first charge you wish to plead guilty to in this case? Count 2 says that on the same day, June 23rd, 2022, in the city of Mentor, Lake County, Ohio, you knowingly obtained, possessed, or used cocaine, a Schedule II controlled substance. That's called possession of cocaine, felony 5, same Revised Code Section, Division B also controls that. Do you understand that charge? And is that the second and final charge to which you wish to plead guilty in this case? You understand if you plead guilty to these charges you are admitting you committed these crimes. You understand if you had any defenses to the charges, you give up those defenses by pleading guilty. You understand by pleading guilty, you are giving the court the power to sentence you immediately. You understand that any rulings previously made by this or any other court on this case prior to this moment could not be appealed because you're pleading guilty now. And you understand these crimes do not merge, meaning you can be sentenced, you can plead guilty and be sentenced on both, and those sentences can be consecutive with one another for a total of 24 months in prison. You have certain trial rights. You're giving them all up by pleading guilty. I will explain them to you one at a time. I need to make sure any question about what I'm saying, or if you need a better explanation, you need to speak up and let me know. Otherwise, I will assume you understood and answered the question that I asked you. Fair enough? You don't have to plead guilty. You have a right to have a trial to determine whether you're guilty of any crime. That trial would automatically be by a jury in this court unless you decided you wanted a non-jury trial. A non-jury trial is a trial where you want the judge not only to make all of the decisions throughout the case, but you want the judge to make the ultimate factual determination in the case whether the state can prove your guilt beyond a reasonable doubt. You understand that? You understand generally that a trial gives you the ability to test every aspect of the state's case, both factual and legal. Understand that with the jury trial, the jury makes a decision. I don't. Whether the state has proved its case